We'll be discussing navigating the current affordable housing landscape. I would like to introduce Christopher Loebsack, attorney with Loebsack and Brown Lee. Today, he will be discussing Section 4024 and Section 4023 of the CARES Act regarding the moratorium on evictions and how property management is impacted.
Good morning, folks. Can everybody hear me okay? Organizers? All right. Well, then let's get started. We got some really good slides for everybody today. Those of you that have been at a session with me before, I've enjoyed doing these sessions over the years, and am looking forward to trying to give a little legal knowledge on an important legal topic. Landlords for the last 8 months or so have been struggling with understanding and using and working within the parameters of the CARES Act that went into effect on March 27th. And so this is a timely opportunity to make sure that everybody has the understanding of what it is, what it means, and how we operate in it. It is still having effects today, and the effects that it has today are ones that are likely to continue into the future, given what we're seeing in the landscape these days with the COVID numbers and the governmental response. Regardless of where we go next, it's pretty clear that there's likely to be some extensions of some of these protections, many of these protections, or all of these protections into past the end of December, even though the official deadlines, if you've been paying attention, the deadlines are all set for December 31st, 2020. But the truth is that it's pretty predictable that something is going to be extended. In fact, many things may be extended. I don't think there's any reason to expect that the government is going to go towards a more loose approach for the next few months until we actually see a vaccine, until we actually are distributing a vaccine. Those sorts of things, I think, are likely to keep impacting the legal landscape and the CARES Act itself. I think the most important thing to keep in mind is that the CARES Act itself doesn't actually have an end date. It's a law, and until it's repealed, it's still in effect. So pushing things out is very easy. Extending the deadlines is a very simple venture, and so I think it's pretty likely that you're going to see some congressional action like that. So I think that makes this still a relevant topic, and we'll go through each of these as best we can. When I teach, when I do this in person, for any association or any group of folks, I always say the same thing, and that is, when you have a question, ask the question, and we'll do our best to answer it so that it's relevant in real time. I don't like waiting until the end for all the Q&A because a lot of it then loses its context. So feel free. Our friends on the moderator buttons back there behind the scenes have been given permission by me to just interrupt anytime and say, hey, Chris, we have a question in the chat box about what you just said. So feel free to do that. I think it helps keep the conversation going and gets your question answered within the context of the screen we're on. So I have no problem with that, and please feel free. And Madam Moderators, again, please jump in anytime. Okay, so we'll go through our screens here. March 27th was when the CARES Act was enacted.
Chris?
Yes.
Chris, this is Kim. I just want to ask, for folks who like to ask questions, we ask that you use the question function, and we will read those. Our plan is we're going to try to let you get through this, Chris.
Yep.
We'll pose the questions at the end of your presentation.
Fair enough.
All right, sounds good. Thank you.
Yep. All right, so let's start off. So the CARES Act, in regards to landlord-tenant law, had two critical sections. This first one we're going to talk about is actually the second of the two sections. It makes more sense to talk about Section 4024 first, even though it was written after 4023. We'll cover Section 4023 second. But Section 4024 of the CARES Act is the one that created the temporary moratorium on eviction filings. There is no question that everybody on this seminar should have heard about the eviction moratorium many, many times over the last 8 months. It comes from this section of the Federal Act, and it imposes a national moratorium on the charging of fees and on the initiating of new evictions for non-payment of rent. So the moratorium language very much was designed to limit the impact of economic consequences from COVID, and so the moratorium itself lasted for a period of time, but the moratorium was designed to cover both charging of late fees or other fees relating to non-payment, and also designed to prevent or temporarily keep new eviction filings related to non-payment of rent from being filed, so that everybody could adapt to and respond to the virus. So the moratorium, it was designed to be temporary, and just like it says, and it in fact has expired now. And likely the moratorium is not going to be the subject of extension because it's already expired and has expired for a number of months. There's probably too much negative pressure from the industry to allow a moratorium itself to be reenacted. I say that, knock on wood. But many other parts of this law that we're going to talk about very easily could be extended further. The late fee and the non-payment evictions, and again, the non-payment evictions is pretty clear. It was never prohibiting filing of cases that are for other reasons. So if you, from the very beginning, from March 27th when the statute went into effect, if you had a tenant who was arrested for drug dealing on your property, nothing about the moratorium then or now prohibits you from filing an action and going forward to conclusion. The only issue you had for a period of time was that for some period of time in some parts of this state and others, the courts weren't conducting business for a while. But on June 1st, North Carolina's courts went back to business. So since June 1st, there's really no reason why any case for something like criminal activity or for unauthorized occupants, or if they have a pit bull on the property that you didn't know about, all of those claims are valid and enforceable and can and should and will be heard by the courts. And so that to me is a key piece of remembering what we're dealing with here. If it's not about money, then there's a whole different analysis. And only when it's about money do we have to make sure that we're complying with the CARES Act. The moratorium applies to rental property that's subject to a federally backed mortgage loan, whether an individual property manager, whether a single family homeowner who rents their house out, or a multifamily apartment complex. So the CARES Act really is about figuring out what kind of mortgage loan you have. If you own your house outright, then the moratorium never applied to you. And so only if you have a federally backed mortgage loan of some sort are you covered. That also includes federal programs like VA loans. It also includes, I believe the USDA actually has loans, and HUD, of course. Any HUD program makes you a covered program. So if you have a person on a Section 8 voucher, then you are a covered property as well. And so for this audience, that's a sizable issue that you need to be mindful of. But if you don't have a mortgage at all, or if your mortgage was privately financed and doesn't have any HUD backing, and you didn't have Section 8 voucher, then you weren't covered by the moratorium, and you could proceed at any time, even with non-payment cases, because it never applied to you as a matter of definition. Okay. So, federally backed mortgage loans, let's look at what those are. VA loans, for instance, are covered under because it's a federal program. Department of Agriculture, USDA, they have a funding program for farm-related properties. Federal Housing Administration, FHA, they have loans. HUD, of course, as we talked about. Then there's Fannie Mae or Freddie Mac. Or it's occupied by a housing choice voucher program resident or other covered housing program. There's housing programs that HUD operates that relate to elderly and relate to disabled folks. So if you have any of those properties, you are considered to be federally backed because the federal government has a program that you're participating in or that your program is involved with. So it's pretty good list, covers everything that might be federally related. And so if you're in one of those programs, it's pretty apparent that you were always subject to the CARES Act. Next slide. Covered housing programs. So here's a good list. Public housing, of course, CHA and all of its entities across the state that are similar. Public housing providers have contracts. Our trivia question from just a second ago, the housing assistance providers of North Carolina, all of those are public housing. Section 8 housing choice vouchers, of course, those are all covered programs. Section 8 project-based rental assistance is a program that comes up periodically. And then I mentioned earlier, here's Section 202, supportive housing for the elderly. Again, a HUD program that helps folks that are providing housing for the elderly folks. And then persons with disabilities, Section 811, another HUD program that helps out, provides housing for folks that have mental impairments or other disabilities. So all of those are obviously covered. Another one, there's a housing opportunities for persons with AIDS program. So if you have a specialized property that involves that program, it would be covered. The McKinney-Vento Act homeless assistance grants. There's a lot of housing across the country that operates under this act to help the homeless get housing. And if you're operating one of those, then of course you're covered as well. Section 236 preservation program participation, that's a much smaller program. Home investment partnerships, if you have one of those. The rural development multifamily housing, there's a lot of, we have a couple of clients at our firm that have rural development multifamily housing. So lots of small town landlords in this category. So if you have a small town property, you're an out of the way place, but you're trying to provide multifamily housing in a rural area, you often are participating in this program. So even in smaller towns, you can have HUD-based housing. It's not just a big city issue. And then of course, low-income housing tax credit properties. That encompasses a pretty wide swath of folks. And so if you've got low-income housing tax credits at your property, you're also considered a federally backed property and therefore covered under the CARES Act. So forbearance, so let's talk about, before we move on to 4023, let's talk about the actual practical impacts of 4024. So when you're dealing with 4024, the real operative issue was the 120-day deadline. So if you have a 120-day deadline, the moratorium was in effect until July 25th. And after July 25th, there was a section, and this is the one where I think it affects landlords the most. 4024C is the notice statute. It's the notice provision of the law. And so the biggest issue with 4024C for landlords then and now is if you are a covered property, we just went through the universe of covered properties. It could be anybody who participates in a HUD program as well as anybody that has a Fannie or Freddie involved loan. It's a lot of people that are in that category. Well, the thing about the CARES Act is that the moratorium against evictions lasted 120 days. The act hasn't expired. The act is a law. It is permanent. The definition of covered property is still in effect. If you are a covered property, you are still a covered property today. There's nothing about covered property that had a timeline. Only the moratorium on eviction filings, only the moratorium on charging of late fees had a timeline. The most common misunderstanding of this statute is that after July 25th, it didn't apply to people anymore. It's totally not true. There isn't a single thing in this statute. There isn't a single thing in the law. There isn't a single thing in any of the rules or regulations that have been issued about it that says after July 25th, you're no longer a covered property. It's not true. You are. Today, you are still a covered property. And the moratorium may not prevent you from filing eviction cases, but Section 4024C is a catch-all provision that I think is creating a lot of consternation across the country. There's a lot of different ways that 4024C is being dealt with across the country in different jurisdictions. But it says that if you are a covered property, you may not evict a resident from your unit for any reason unless you have first given them 30 days notice of your demand that they vacate the premises. So the question we get from clients over and over and over is, do I still have to give a 30-day notice? The moratorium expired back in July, and the answer is, I think you do, because the definition of covered property still applies to you unless you've refinanced your mortgage and now don't have a federally backed mortgage. But if you still do, or you're still participating in these programs, you have to be considered a covered property. The definition is still there. And 4024C says that covered properties are required to give 30 days notice to a resident before they can initiate an eviction action. Most landlords want that to not apply because the moratorium no longer applies. But the truth is that the statute doesn't say that. And that's borne out by the way our Chief Justice in North Carolina has handled the situation. Early on in the pandemic, our Chief Justice, Sheree Beasley, entered some emergency directives into the law. And the Chief Justice of the Supreme Court, of course, is in charge of emergency response in the court system. The governor of North Carolina is responsible for emergency response for the people in all governmental agencies, but the Chief Justice is responsible for the court operations system. So while the governor can issue executive orders, he cannot issue executive orders to the courts. Only the Chief Justice can. So the Chief Justice entered some orders in regards to court operations during the course of the pandemic. And one of them is Emergency Directive 18, which requires an affidavit to be submitted with every eviction case filed in this state, no matter what the reason for the filing. If you are filing a complaint for summary ejectment, you must include an affidavit. And that affidavit includes, as question number one, is your property covered under the CARES Act? The reason why that's still relevant and why it's still required is because the CARES Act hasn't actually expired. The moratorium on non-payment evictions expired in July, but the CARES Act itself hasn't expired. And so the definition of whether your property is covered or not is still relevant to North Carolina operations because Chief Justice Beasley still requires you to notify the courts if you are covered. Now, the only reason that can be so is because the Chief Justice expects that if you are covered, you will be providing notices in accordance with 4024C. Now, lots of people in lots of other states have gotten their courts to take a different approach, have gotten their courts to interpret it differently, that 4024C should only apply to non-payment of rent breaches that occurred during the moratorium period. But the truth is that the law doesn't say that. And our Chief Justice takes a different interpretation of it. And our landlords in this state are still required to submit that CARES Act affidavit attesting to whether they are or are not a covered property with every case today. And so because of that, the 30-day notice provision still has to be at the top of your mind for every case. There's no way that I think it's appropriate for a landlord to believe that they can tell the court that they are a covered property and then show up for their non-payment eviction case having given a standard 5-day late letter or something of the sort to their tenant and have the court find that that was appropriate. You know, if the court knows that you're a covered property, the magistrates hearing your cases are going to expect to see a 30-day notice. And so whether you have to give one or don't have to give one is a matter of open debate among all the legal scholars in the country, and different states are coming down with different explanations. But at the end of the day, in this state, we know that you have to provide an affidavit with your case, and that affidavit has to identify yourself as a covered property. And so if you do, it is a trap waiting to spring if you show up without a 30-day notice after telling the court that you were a covered property. So keep that in mind. That's the one that we get the most question about, and there's no doubt that this is a disputed item. But in North Carolina, with Emergency Directive 18 in place, it makes it pretty easy for me to advise all of our clients that unless and until somebody says we don't have to, unless Sheree Beasley is going to issue a directive clarifying that we no longer have to give 30-day notices in her opinion is the only one that counts. And until then, the justices across the state are acting in response to her emergency directive. And I think that for landlords in this state, then you have an obligation to continue to follow that procedure until such time as Emergency Directive 18 is changed by someone, and or until a case goes to the Court of Appeals, and the Court of Appeals rules that that's not actually what's required. But again, because it's a federal law, it's unlikely that this issue is going to get challenged by any landlord because it's just simply not worth the effort and the time and the money and the resources to go to court on a temporary basis when this act is hopefully not going to apply forever. So we haven't seen any action where anyone's challenging this provision in federal courts yet, and I don't think it's likely to happen. So until then, Chief Justice Beasley's order is what's required. So remember, the 30-day notice is still a thing, and if your property is covered, you need to be keeping that in mind and issuing a 30-day notice to your residents before you start your eviction case. Again, only if it's a non-payment of rent case, because that was the governing issue. Other cases were exempt from the beginning. And so I think it really is just a matter of non-payment of rent cases that you need to be mindful of. Okay. So let's move on to 4023. Let's go backwards a section. So Section 4023 deals with forbearance of residential mortgage loan payments for multifamily properties with federally backed loans. So this is a very important piece of the puzzle. In the post-moratorium world, after July 25th, this is where the rubber really is hitting the road. So this section, 4024, covers multifamily rental real estate properties that have 5 or more units with federally backed multifamily mortgages. So again, if you are only a single family residence owner and you have just one unit, then this part doesn't apply to you. But if you have even a small number of multifamily units, anything more than a quadplex, 5 or more units, this would apply to you in theory. And so even if you just have a quadplex, you're still exempt from this part. But everybody else that has any sort of multifamily functionality is governed by this. And again, as a federally backed multifamily mortgage, then you are eligible to use the provisions of this statute. What this deals with is getting forbearance of your mortgage loan. Now, many of you may have heard that there is a separate provision that was enacted by the federal government dealing with single-family mortgage loans, and that's true. It's not part of the CARES Act. It was done by administrative action. But the federal government and the HUD program and FHFA have created a program that allows for single-family rental owners to get forbearance on their loans as well. So we'll commingle that towards the end of this. Let's go through what the actual CARES Act says, and then we'll talk about the FHFA forbearance as a separate item.
Chris?
Yes.
I want to interrupt you for 1 second. You are so popular that we've got several hands that are raised. I just want to remind folks that are participating that if you could place your questions using the question function, we'll get to those when we get to the Q&A section of Chris's presentation. Thank you.
No problem. We're curating a parking lot, right?
That's what happens when you're good, Chris.
Yeah, trust me. I have done this so many times on so many different topics over the last 8 months that the questions are fast and furious most times. So I'm I'm going to rely on you to weed out the duplicates. Okay. So next slide, 4024. Let's talk about a little bit more. Let's dive in a little deeper. The forbearance period, 4024, there's just a typo there, sorry folks, allows mortgages up to 90 days of forbearance, mortgagees. So if you are struggling because of the moratorium, if you're struggling because of the impacts that the COVID pandemic is having on your rental income collections, the federal law, the CARES Act, gave you the opportunity to speak to your mortgage provider and ask for forbearance of your loan. In essence, you're allowed to ask for a timeout, as it were. And you can do it in any way, shape, or form you want to. As long as you were current on your loan as of February 1st, 2020, you can submit a request to your loan servicer in writing or verbally. By email is the most common. And all you have to do is tell them that you have financial hardship because of the COVID-19 emergency. And they are required to let you request, they are required to let you have a forbearance, i.e. postpone making your mortgage payment for a period of 30 days. And you are allowed to do that at any time from March 13th, 2020 until December 31st, 2020, as it stands now. So you could, all the way up to December 31st, as the law is written today, you have the opportunity to, on the day before New Year's, reach out to your loan servicer and request a forbearance of 30 days. And 4023 allows you to extend that up to 90 days. So you could, in theory, under the laws that exist right now, get forbearance all the way from now until December 31st. And if you reach out to your loan servicer in writing or verbally and ask for that forbearance, they would have to give you up to 90 days. So in theory, a landlord could be in forbearance through the end of March if they timed it exactly at the end of the period. And that's why this is going to carry on for a number of months still, even though we're in November now. There's still the possibility that clients, landlords could be in forbearance through the end of March if they use the system exactly at the end. And so we have to keep that issue at the forefront of our minds for a number of months yet, even if there's no extension. And the odds of that December 31st deadline being extended, I personally think they are for sure better than 50-50. Exactly what odds depends on a number of factors, but I think that the December 31st deadline is likely to be extended for some period of time. It's just a question of how and when and how much. So, next slide. So the restrictions, while you're in forbearance, the landlord, if you ask for forbearance so that you don't have to pay your mortgage for 1, 2, or 3 months, and again, you're in charge of how many months it is. The loan servicer doesn't have any discretion about that. If you ask for forbearance, they have to give you 30 days. And if you ask for a renewal, you can do that twice more. And again, your loan servicer doesn't have any discretion, so they have to give it to you. For any amount from 0 to 90 days is within the landlord's control. All they have to do is ask. But while you are in that phase, while you're in forbearance, no matter how many days you pick, you may not evict anybody for non-payment of rent or fees. So if you go into forbearance today, your non-payment of rent cases have to stop. There's no way around it. There's no methodology. It's as though the forbearance is the same as the moratorium period from March to July. You cannot file an eviction case for non-payment of rent or other fees while you are in forbearance. You also may not charge fees or penalties for late rent payments while you're in forbearance. You may not penalize your tenants for not paying. If you are not paying your mortgage, then they shouldn't have to pay penalties either. And so that's the way the statute is set up to make sure that landlords are, they're able to survive by seeking forbearance, but while they're surviving, they're not allowed to penalize their tenants who are suffering the same problems. You must wait, and again, here we're back to the notice provision. The key thing about the forbearance period is that no matter when it ends, because again, you're the landlord, you're in charge of how long is my forbearance going to last. But it has to last 30-day increments. So you can have 30, 60, or 90 days worth of forbearance. And the notification statute, 4024C, is in play again, because once the forbearance period is over, that's the first time you're allowed to send a 30-day notice. You may not send one during your forbearance. So I like to tell people to think of it as though the list above, while you're in forbearance, you may not evict for non-payment of rent, you may not charge fees or penalties for late rent. There should really have been a third box in the law. There isn't, but there should have been. It should say item 3 that you cannot do while in forbearance is send any notice to vacate to any of your tenants. Because that's the truth. You're not allowed to send notice to vacate until your forbearance period runs out. So if you ask for 30 and then you ask for a renewal, but you don't want all 30 days, there isn't a provision for that. You either have to have 30 or 60 days of forbearance. And if you seek 60, then you have to wait till day 61 to send your notices to vacate for anybody who is behind, who hasn't been paying you rent while you weren't paying your mortgage. So keep that in mind. You cannot send notices to vacate concurrently with your forbearance period, however long it is. Okay, let's see what's next. Excellent, Q&A. Okay, so we've got a long list of Q&A, but let me cover one last thing before we jump into that. The governor has issued some executive orders that sort of parallel this. And I want folks to know that in North Carolina, while the governor's executive orders can be their own seminar all unto themselves, but I don't want to pretend as though they aren't relevant, because I know the questions that my clients ask me all the time. So, and there's also a CDC order that is relevant. And again, I don't want to pretend like that doesn't exist and that you don't have questions about it. But the content of the seminar was designed to be CARES Act related. And so I want to just touch on this briefly for everybody so you know. The CDC order that went into effect on September the 4th has a similar time frame to it as the forbearance section we just talked about. The CDC order also runs through December 31st as it's currently written. The CDC order basically says that because of the health risks of COVID, the government wants to make sure that people are not being evicted and made homeless during that period of time through December 31st. And so the CDC order gives tenants an opportunity to submit a written declaration to you as the landlord saying that they meet a list of 7 criteria And if they do, then they should not be locked out of their premises. The most important thing, and again, I give seminars about just the CDC order that lasts just as long as this one does. So again, we can't do all of the in-depth analysis, but I want you to walk away at least understanding the main high point of the CDC order is that the declaration given to you by the tenant does not stop you from filing cases. If you have an eviction case, if they're not paying their rent, even if they qualified to give you the CDC declaration, the law is now very clear, and the governor issued an executive order 10 days ago that makes very clear that in North Carolina, you are permitted to file those cases. You are just not allowed to follow through on removing those people. You may not issue a writ of possession to lock them out if they've given you a CDC declaration. So if you get a declaration and you're not sure what to do or how to do it, reach out to your attorney and get some advice. The attorneys are all pretty familiar with it now. If you've got an attorney that helps you with landlord-tenant matters, reach out to them if you ever get a CDC declaration from a resident, because they can help you navigate the issues. But the big takeaway for you as a landlord is no, the declaration, despite what the tenants have been told or misunderstood, the declaration does not stop you from filing a case. The declaration does not stop you from proceeding with a case and securing your judgment. The declaration only stops you from issuing a writ after you get that judgment and attempting to lock them out. You have to wait until after December 31st before those cases, people who have given you a CDC declaration, can have a writ issued and executed and locked out. And then the governor's order that just came out a couple days ago, there we go. Hey, what's that? The governor's order, the governor's order is very clearly designed to make sure that we are all clear on how we're handling this. And he made a point of saying that if there is a declaration tendered, the courts can hear the case. It also allowed, the governor's executive order also made clear that he is directing the courts to conduct hearings for any landlord that wants one on the issue of whether the resident is being truthful in their declaration and whether they have in fact met all the criteria to be eligible for a declaration. That is a huge change, a sweeping change from what the courts were doing, which is ignoring that issue and not conducting hearings at all. And now, effective immediately, if someone gives you a CDC declaration, the governor has made clear that you are entitled to a hearing if you ask for one. And if you want to have a hearing, then you should do it in front of the magistrate, and you are allowed to explore whether or not that tenant does in fact meet all of the eligibility criteria. And if they don't, then the declaration should be declared inapplicable by the magistrate, and the case should proceed to conclusion. We haven't done one yet because it's so new. We're anticipating doing some of those in the coming weeks because there are plenty of our clients that have plenty of people that have tendered declarations that they know to be not fully truthful. And that's unfortunate, but it's just the reality of the situation. So there's plenty of folks who we anticipate being able to have hearings on soon, but we don't actually have any experience with how the courts are, in fact, running it from start to finish under the new executive order from the governor. But just know that that's there. The governor's executive order also mentions the HOPE program. Applications for the HOPE program ended yesterday, I'm told, which makes this less and less of a problem as time goes on. But if you get a letter from one of your residents that had a HOPE loan application go through and pre-qualified them, then again, you should reach out to your favorite landlord-tenant attorney for some guidance to make sure you're handling it right. The governor's executive order did address how he wants the HOPE program to work vis-a-vis eviction filings, and he considers that if a tenant has a HOPE program application letter, they are just as protected as if they had given you a CDC declaration. So if you get a HOPE letter from one of your residents, make sure that you reach out to your favorite landlord-tenant attorney and ask them for guidance on how that should apply to their situation, because it's an item that the governor made up in his executive order, and so you want to make sure you got it. It's not a matter of law. In other words, it's not North Carolina landlord-tenant law. It's an emergency declaration from the governor. So make sure you get some advice if you have that happen. Okay. So having covered all of the highlights, let's go climb the hill of the question mound.
Where can I get a copy of the affidavit?
The CARES Act affidavit is available from the North Carolina Administrative Office of the Courts or at any courthouse. If you go to Google and search NC CARES affidavit, it will take you to the link for the North Carolina Administrative Office of the Courts where the form is available. Your county courthouse will have a copy as well.
Next question. Section 4024. How does this apply if mortgage was not reaffirmed or backed federally?
So if you don't have a federally backed mortgage, then none of the CARES Act applies. If your property either doesn't have a mortgage at all, or has a private money lender, or refinanced its mortgage from a FHA loan into a non-FHA loan during the period of time since March, then you're not a covered property, then none of 4023 or 4024 applies to your property. So properties that are owned outright were never covered by the CARES Act and were never subject to these restrictions. So if your mortgage is not federally backed, then 4023 or 4024 don't apply to it. You're allowed to conduct business as usual, just like you did in February, in other words.
As a landlord or housing provider, if I give the declaration and not file for non-payment of rent, how do I ensure I eventually get my rental payments?
Say that one more time.
As a landlord or housing provider, if I give the declaration and not file for non-payment of rent, how do I ensure I eventually get my rental payment?
It's a good question. Nobody knows. The eviction process is the only way that really gives you the power to hold people to their tasks. And so if you choose not to file, or if you file only in accordance with the timeline under the law, there isn't really another way to ensure that they do pay you. The collection process obviously is even more long and arduous, and if tenants really are suffering economic hardship, it doesn't matter how many collection letters they get, they still, you can't get blood from a turnip, as they say. So the biggest solution is to make sure that you are connecting your residents with housing assistance programs. The HOPE program was one. Again, the applications period closed yesterday, but there are still many, many others in Mecklenburg County, and I'm sure that the powers that be here at CHA have those resources readily available for you. There's a pretty good list. The ERAP program is very popular here in Mecklenburg County, and there's also a number of others that apply. In every jurisdiction in the state, there is a local rental assistance program that's in effect now. There's also, in addition to the statewide HOPE program, which is using the COVID money that the federal government gave us. So the easiest way to make sure you get paid is to find a connection for your tenant to make to get some housing assistance payments.
Okay, next.
Yeah.
Landlords typically need rent to pay mortgages and taxes. When do we get our money back from what could be months of moratoriums and declarations protecting tenants from payment?
I don't know. I think part of the problem is that the federal government expects you to just man up and do your civic duty because they're doing a bad job of managing it themselves. Congress is refusing to give payments that should have been made months and months ago. There should have been a rental assistance program on a national level enacted months and months ago, but Mitch McConnell and Nancy Pelosi have been having a personal war about it, and the losers are us. I make no bones about it. Congress has failed us all with their tit-for-tat nonsense. The two of them should both be ashamed of themselves, and the landlords, my clients, are the ones suffering the consequences because of it, and that's shameful.
Okay, thank you. This concludes the Q&A session.
Like I said, I feel very strongly about that. I represent landlords all day, every day, and I know what the issue is, and it's just beyond the pale for me that both sides of Congress are letting everybody down. Federal rental assistance should have been in place months ago. Okay, what else we got?
I actually have one more question.
Yeah.
The CDC order states that a covered person has, quote, used best efforts to obtain all available government assistance for rent or housing. What does that mean?
Well, they use the terminology best efforts, as many statutes or rules often do, specifically to be a little vague to give some room for interpretation. So there's no way of knowing what best efforts are going to consist of, except on a case-by-case basis. But that is one of the primary ways in which landlords can now, especially in North Carolina, take advantage of the governor's permissive ability to have a hearing to conduct an explanation or inquiry into that exact issue. What exactly have you done? And what efforts did you make? And the magistrate would be the one in charge of deciding whether those were best efforts or not. The truth of it is that many of my clients are very convinced that the tenants that are giving them declarations aren't doing anything, haven't applied to the HOPE program, didn't apply for other rental assistance housing, or they made one phone call and that was the end of it. When, in Mecklenburg County, there are, at least 10 different programs that you could reach out to for housing assistance in this one county. And so I think in this county, it's going to be very easy for landlords to say, all you have to do is make phone calls. You're the one that doesn't have the money. It's at least incumbent on you to spend the time necessary to get on the phone and wait on hold if you have to get an application in. If you're not even willing to do that, then how can that be best efforts? And I think that's really, but really what constitutes best efforts is going to be examined by the magistrates at these hearings. And of course, there's a spectrum across which you can imagine some might be sufficient and others won't. But there's not a black and white answer for what best efforts consist of. But I think it's pretty easy to say that if you haven't applied to at least a number of different available options for rental assistance, you're probably not using your best efforts. If you're at the courthouse, there's a form. I've got it right here. In Mecklenburg County's courthouse, there's a 2-page list of resources for resident assistance. And it goes on and on and on. If you as the resident can't provide information that says, I took this form and I've tried at least 80% of these, that's a pretty solid standard. And so I think there's a lot of reason for landlords to think that, if you haven't made multiple applications or multiple inquiries, that's probably not going to meet the bar of best efforts.
Are there any grants available for landlords?
I don't know for sure what all is out there. I think the forbearance option is the one that is most relevant. I haven't heard of any programs where the government is giving landlords money. And again, that's part of what should have happened a long time ago at the congressional level. But it sort of touches back on the idea that the forbearance component that you have is really a tool that the landlord can use to help itself stay afloat. And I think a lot of landlords, like most of us, have tried hard not to use that other than in case of emergency, break glass. And so we haven't had very many clients who actually took a forbearance to date. But I think if we don't get some more assistance at the federal level, I think there's going to be more and more folks that think long and hard about it before we get to December 30th. We'll see.
Thanks, Chris. I wanted to remind the participants, you had so much great information that we are going to be having a post-symposium resource center.
Nice.
Where we're going to be including all the documents provided for us, resources that they'll be able to access, in particular as it relates to rental assistance programs in Charlotte, Mecklenburg County.
There are many. The ERAP program is the most well-known. It is super well-funded. I believe they started out with $20 million from the state earlier this year, and that will go a long way in one county. Even with a county the size of ours, that's still a lot of rental assistance that's available.
All right, I think we had one more question.
Sure.
What does the
Oh, wait, I lost you. Try that again.
What does the CARES Act say about HOA late payments?
Nothing. HOAs aren't mentioned in the CARES Act anywhere. But if it is a monetary obligation of any kind, it doesn't, late fees or other monetary penalties for late payment of rent, you would have to imagine that an HOA fine falls into that category. But again, that only applied during the moratorium period, and it only applies now if you're in forbearance. So if you're not in forbearance, we're outside of the original 120-day moratorium, so it wouldn't apply now. Unless your property is in forbearance under the federally backed loan program.